In 1961, Clarence Earl Gideon was arrested in Panama City, Florida, for breaking into a pool hall and stealing money from vending machines. When taken to trial in the state of Florida, Gideon did not have the money for a lawyer. At the time, the state of Florida only provided lawyers for those that had committed capital offenses. The Florida Supreme Court denied Gideon a lawyer because this was not a capital case and Gideon was not impaired in any way.
I said I want you to appoint a lawyer to represent me in this trial.
Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person has been charged with a capital offense.
I'm entitled to a lawyer.
Let the record show that the defendant asked the court to appoint counsel to represent him in the trial. The court denied the request, informed the defendant that the only time the court could appoint counsel to represent a defendant was in cases where the defendant was charged with a capital offense.
He attempted to defend himself, but he did not do a very good job. Gideon was then sentenced to 5 years in prison.
While in prison, Gideon wrote his own writ of certiorari, which is a process for seeking judicial review and a writ issued by a court that agrees to review. Gideon claimed that he wanted his case heard by the United States Supreme Court because he believed his constitutional rights had been violated.
3 things they make you do. First, petition the Florida court for a writ of habeas corpus. Then ask the United States Supreme Court to issue a writ of certiorari. And I got to sign an affidavit saying I can't pay court costs even $100. That's an in forma pauperis application.
Some of the boys are getting their hopes up.
Yeah.
No, I've seen plenty of petitions to the Supreme Court written in this room. I've even written a couple myself.
Any of them ever granted?
The court agreed to review his case in 1963. 5 amicus curiae briefs were reviewed during this trial. There were law clerks assigned by Chief Justice Earl Warren to review the many cert petitions filed. The Solicitor General was Archibald Cox, and he argued the case in front of the Supreme Court. During this case, Abe Fortes represented him and orally argued that it was unconstitutional for Gideon to not be provided a lawyer while on trial.
I believe this case dramatically illustrates that you cannot have a fair trial without counsel. Under our adversary system of justice, how can our civilized nation pretend that there is a fair trial without the counsel for the prosecution doing all he can within the limits of decency and the counsel for the defense doing his best within the same limits? And from this clash, the truth will emerge.
His previous record of 4 felony arrests indicates that he was not wholly unfamiliar with criminal trial procedure. Judge McCrary, who tried the case, says, and I quote, that it is his opinion that Gideon had both the mental capacity and the experience in the courtroom at previous trials to adequately conduct his defense. He did as well as most lawyers could have done in handling his case, unquote.
After the oral arguments, a conference was held to decide the opinion of the court. The opinion of the court was that the right to an attorney is a fundamental right for a fair trial. They stated that due to the Due Process Clause of the 14th Amendment, all states would be required to provide counsel in criminal cases. There were 2 concurring opinions written by Justices Clark and Douglas. Gideon was then tried in Florida with an attorney present, and he was acquitted of all charges.
Clarence Earl Gideon, the jury finds you not guilty. Court is adjourned.
This is a landmark case because now, even those who cannot afford a lawyer have to be appointed an attorney while on trial.